We've all been there, haven't we? Or, seen it happen, a job ending. It's pretty universal. But how that actually goes down, especially somewhere like South Africa with its own unique legal setup, that can be really complex.
It definitely can.
So today we're doing a deep dive into how employment relationships end in South Africa. And we're going to focus quite a bit on one specific area that seems to cause a lot of confusion: resignation.
Yeah, that's a big one.
Our source material really shines a light on just how strict the rules can be and the potential traps for employers if they don't get it right.
And that's really the core mission here for you listening, to understand just how vital it is to follow the correct legal steps and, crucially, keep the right paperwork when someone leaves.
Right.
This isn't just, admin for the sake of it. It's about managing significant risk.
How significant are we talking?
Well, think about this. If a case ends up at the CCMA, that's the Commission for Conciliation, Mediation, and Arbitration, and the employer hasn't followed the right procedures or, crucially, doesn't have the evidence.
Uh-oh.
Yeah, they could be facing damages up to 12 months of the employee's salary.
Wow. 12 months, that's huge.
It's a massive potential hit. It really underscores how South African labor law, shaped by its history, strongly protects employees.
Yeah.
Fairness is key, meaning employers carry a pretty heavy burden of proof.
Okay, so before we really dig into resignation specifically, maybe we should just quickly map out the different ways a job can actually end. Because it's not always just quitting or being fired, is it?
No, definitely not. Our sources actually lay out 7 distinct ways.
7.
Okay, let's hear them.
All right. 1, the employee resigns voluntarily. That's the one we'll focus on.
Okay.
2, the employer dismisses the employee after a disciplinary process. Think misconduct.
Right.
3, dismissal after an incompetence process. So poor work performance or maybe medical reasons.
I got it.
4, retrenchment, due to staff reductions, operational requirement.
Layoffs, basically.
Essentially, yes. 5, the employee hits the agreed retirement age based on a contract or policy. Standard retirement.
6, a fixed-term contract just runs out on its end date.
Simple enough.
And finally, number 7, sadly, is if the employee passes away.
That really covers all the bases. 7 distinct paths.
Exactly.
And while, like you said, each one has its own rules and potential issues, that first one, resignation, seems to generate so many questions for everyone involved, really.
It does. It seems simple on the surface, but the nuances are important.
So let's peel back those layers now. Because just saying I quit, well, it's often not the end of the story, is it?
Not quite. So resignation, fundamentally, is a unilateral act. It's the employee deciding to end things.
Unilateral meaning they don't need the boss's permission.
Precisely. The employer doesn't need to formally accept it for it to be legally valid. That's a key point.
Okay.
But, and this is important, the employee still has to work their notice period, whatever's in the contract or required by law.
Right. You can't just walk out in that second, usually. So someone emails, I resign effective immediately. Legally, they've resigned, but they still owe notice.
Generally, yes. The resignation is effective, but the notice period obligations remain.
Okay, that makes sense. But what about when people have second thoughts? We hear about this. Can someone actually take back a resignation once they've sent it? Or is it final?
The retraction question. Legally speaking, an employee doesn't have an automatic right to just withdraw their resignation.
No take-backsies by default.
Kind of, yeah. However, they can agree with the employer to retract it. It needs mutual agreement.
So the employer has a choice.
Exactly. They basically have 2 paths if an employee asks to stay. 1, refuse the request. The original resignation stands, notice period applies, end of story.
Okay.
2, accept the request. If they agree, great. The employment just carries on as if nothing happened. No break in service.
And no need for a whole new contract.
Nope, no new contract needed. But if any terms are going to change, that needs to be agreed upon by both sides.
Yeah.
No unilateral changes allowed.
So the power shifts quite a bit to the employer once that resignation letter lands.
It does.
But should an employer always just accept a resignation at face value? What if it seems off? Someone quits in anger, maybe. Feels impulsive.
That's a really good point. And it touches on sound practice versus just strict legality.
Right.
Our sources actually recommend that if a resignation looks suspicious, or maybe it was done in the heat of the moment, it's wise for the employer to actually talk to the employee.
Try and understand what's going on.
Exactly. Discuss any underlying issues. And crucially, consider allowing a cooling off period.
A cooling off period? Why is that so important?
Well, it's about risk management, really. It helps avoid potential claims later on, things like constructive dismissal.
Where the employee claims they were forced out.
Precisely. Forced to resign because work conditions were intolerable. Or maybe an unfair labor practice claim. Giving that cooling off time lets things settle, allows the employer to check the employee's real intention.
It shows the employer acted fairly.
Yes, demonstrates fairness and diligence. It's not like the movies where someone dramatically quits and storms out and that's it. There's a real legal tightrope for employers there.
So it's about being legally sound and relationally smart. Okay, that leads me to another practical point. Does it always have to be in writing? The resignation itself.
Good question. So the Basic Conditions of Employment Act generally says yes, it should be in writing.
Generally. Is there an exception?
Yes. The main exception is if the employee is illiterate.
Okay, that makes sense.
But, and here's where case law comes in, courts in South Africa have found that an oral resignation can still be valid.
Even though the act says written, how does that work?
It comes down to proof.
Yeah.
The employer has to be able to clearly show that the employee's actions were totally unambiguous, that they absolutely clearly intended to end their employment.
Actions speak louder than words, maybe.
In this context, yes. The source gives some solid examples, like the employee says, "I quit," and walks out immediately. Or they hand back company keys, laptop, clear their desk, and leave.
Pretty clear signals.
Or maybe they resign verbally, and then, the next day they start a new job somewhere else. That's strong evidence of intent.
I can see how those actions paint a clear picture. Still, relying on an oral resignation sounds risky. Easy for misunderstandings to happen.
It definitely can be trickier to prove. It can easily become a he said, she said scenario.
Yeah.
That's why if it happens orally, it's absolutely crucial for the employer to immediately document everything in writing. Record the employee's words, actions, the date, time, any witnesses.
Create that paper trail.
Exactly.
Yeah.
And then formally communicate with the employee, also in writing, confirming that their resignation is understood and accepted as voluntary. It protects the employer down the line.
Right. Documentation is king. So we've covered actual resignation, written or verbal, with clear intent. But what about the scenario where someone just stops showing up? No call, no email, just gone. Can they basically fire themselves by doing that?
Desertion. No, absolutely not. An employee cannot dismiss themselves. Full stop.
Okay, a categorical no there.
If an employee just disappears without notice or explanation, absence without permission, or desertion as it's often called, that's a disciplinary offense.
A breach of contract.
Yes. And because it's a disciplinary matter, the employer must follow the proper disciplinary procedure.
Even if the person isn't there.
Yes. They need to try and contact the employee, hold a hearing if possible, even in their absence if they've been properly notified, and make a decision based on the facts. This ensures any resulting dismissal is fair, both substantively and procedurally.
So you can't just assume they've quit if they vanish.
Absolutely not. The only way an employee can legally end the relationship from their side is through resignation, clear, intentional resignation. Mistaking desertion for resignation is a common and potentially costly mistake for employers.
Wow. That distinction is critical, isn't it? Between someone actively resigning and someone just being absent.
It really is. It impacts the whole process and the legal standing.
This deep dive really hammers home the point. Ending a job in South Africa, especially around resignations, needs real care. You've got to follow the rules, dot the I's, cross the T's, and keep records. That regulated environment doesn't leave much room for error.
And that really is the so what for you listening. Understanding these details, the difference between resignation and desertion, when an oral resignation might hold up, the cooling off period idea, it's not just about ticking boxes for compliance.
It's about risk.
It's absolutely about managing very real financial and legal risks. And frankly, it's also about fairness and clarity for both the employer and the employee. Understanding the rules protects everyone.
So here's something to think about. Given all this complexity, the potential costs, the need for fairness, how might really understanding these rules change how you handle job transitions? Whether you're an employer making sure you're compliant or an employee wanting to know your rights, how can this knowledge help avoid those messy, costly misunderstandings down the road?